is Jessica Goldrick from McMahon Goldrick Solicitors, and today I'm going to talk about the Mediation Act of 2017 and the advantages of mediation for claimants who have suffered catastrophic injuries. The Mediation Act was signed into law in October 2017, and its underlying objective is to promote mediation as a viable, effective and efficient alternative to court proceedings. Mediation can be used even if proceedings have already been issued, and the Act has been designed so that mediation will coexist alongside the court system. The Act places an obligation to consider mediation on a statutory footing and requires litigants to confirm to the courts that they have considered mediation. So what is mediation? The Act defines mediation as a confidential and voluntary process in which parties to a dispute, with the assistance of a mediator, attempt to reach a mutually acceptable agreement to resolve a dispute. It is a collaborative process which offers a valuable opportunity to individuals to resolve disputes by way of negotiation or agreement, either before court proceedings are initiated or before those proceedings come to trial. Mediation can be particularly effective in complex and serious cases, such as claims for catastrophic or serious spinal injury, birth injury and brain injury. Section 14 of the Act requires practicing solicitors to advise their clients to consider mediation as an alternative to court proceedings. And for this purpose, they must provide their clients with information on mediation services, including details of mediators and information about the advantages and benefits of a mediation. A statutory declaration must be sworn, confirming that advice has been provided to their clients before court proceedings can be issued in court. The mediator is an independent person who has received training in mediation. Both parties will agree on who the mediator will be, and in personal injury cases, the mediator is often a senior counsel who has extensive experience practicing in that area. The role of the mediator is to assist parties to reach a mutually acceptable agreement to resolve the dispute, or in a personal injuries claim, to reach a settlement agreement in the case. The mediator will be given the relevant documents and expert reports in the case in advance of the mediation meeting. In a case for compensation for catastrophic injuries, the mediator will receive copies of the court paperwork, which is called the pleadings, as well as copies of reports from experts such as the rehabilitation consultant, the occupational therapist, the nursing consultant, the physiotherapist and the vocational assessor, so that they are fully aware of the nature of the injury and the potential level of compensation that could be awarded if the case were to go to trial. Section 8 of the Act sets out the steps to be taken by a mediator prior to the commencement of a mediation, including the requirement that the mediator must give a copy of any code of practice to which he or she adheres to. Under Section 7 of the Act, before the commencement of the mediation, the parties and the proposed mediator must sign an agreement to mediate. And this agreement will set out the manner in which the mediation is to be conducted, the manner in which the fees and the costs of the mediation will be paid, the place and time of the mediation, and the fact that the mediation is to be conducted in a confidential manner. And the confidentiality of mediation is now on a statutory footing under the Act. Section 10 of the Act provides that all communications, including oral statements and all records and notes relating to the mediation, remain confidential. Any such statements or records provided for the purpose of mediation will not be disclosed in any proceedings before a court. It may also lead to cases of a confidential nature, concluding at the mediation stage, where the parties may not want details of a sensitive nature being heard in open court. So what are the advantages of mediation in personal injury cases? Litigation can often be a difficult and stressful process for claimants, particularly for those who've suffered a catastrophic or life-changing injury. Mediation offers many advantages to parties to litigation, as both sides are encouraged to reach a compromise without going to a full hearing in court. It is a flexible process that can be tailored to fit each individual case. The mediator is a skilled professional whose aim is to try and secure agreement between the parties in a non-adversarial environment. The mediator can engage with the parties both together and separately to try and narrow the issues and bring the parties towards resolution. It can also be a more cost-effective way of resolving a case, as it saves on the legal costs of proceeding with the full trial of the case. Mediation can be particularly effective in cases for claimants who have suffered life-changing injuries, such as a spinal injury, brain injury, or birth injury, as these cases are more challenging and complex than other personal injury cases and require extra care, time and skill in achieving a good outcome. We at McMahon Goldrick Solicitors pride ourselves on the standard of care that we offer to our clients. We act exclusively for individuals and families that have been affected by spinal cord injury, traumatic brain injury and birth injury, resulting in a permanent disability. Please, as always, email or telephone us with any queries that you may have on a fully confidential and non-committal basis. Thanks for your time today.